Chapter 2 Human Relations Civil Code Article 19 Every person must, in the exercise of his rights and in the performance of his duties, act with justice, give everyone his due, and observe honesty and good faith. Article 20 Every person who, contrary to law, willfully or negligently causes damage to another shall indemnify the latter for the same. Article 21 Any person who willfully causes loss or injury to another in a manner that is contrary to morals, good customs, or public policy shall compensate the latter for the damage. Human relations. In general, Articles 19 to 36 are devoted to the regulation of human relations. In these articles are formulated some basic principles that are to be observed for the rightful relationship between human beings and for the stability of the social order. Principle of damnum absque injuria. Well settled is the maxim that damage resulting from the legitimate exercise of a person's rights is a loss without injury. Damnum absque injuria, for which the law gives no remedy. In other words, one who merely exercises one's rights does no actionable injury and cannot be held liable for damages. This principle, however, is premised on the valid exercise of a right. Under this principle, the legitimate exercise of a person's rights, even if it causes loss to another, does not automatically result in an actionable injury. The law does not prescribe a remedy for the loss. This principle does not, however, apply when there is an abuse of a person's rights, or when the exercise of this right is suspended or extinguished pursuant to a court order. Indeed, in the availment of one's rights, one must act with justice, give others their due, and observe honesty and good faith, as decided in Amone v. Gutierrez, Supreme Court Records Annotated, Volume 351, page 731 and 736. Amone v. Gutierrez. Facts. Petitioner in this case commenced the demolition of respondent's house on May 30, 1986, under the authority of a writ of demolition issued by the RTC. The records, however, show that a temporary restraining order enjoining the demolition of respondent's house was issued by the Supreme Court on June 2, 1986. It was also found that based on the Certificate of Service of the Supreme Court Process Server, a copy of the Certificate of Service of the Supreme Court Process Server, a copy of the TRO was served on petitioner himself on June 4, 1986. Petitioner, however, did not heed the TRO and he pursued the demolition of respondent's house until the middle of 1987. In holding the petitioner responsible for damages, the Supreme Court ruled, although the acts of petitioner may have been legally justified at the outset, their continuation after the issuance of the TRO amounted to an insidious abuse of right. Indubitably, his actions were tainted with bad faith. Had he not insisted on completing the demolition, respondents would not have suffered the loss that engendered the suit before the RTC. Verily, his acts constituted not only an abuse of a right, but also an invalid exercise of a right that had been suspended when he received the TRO from this court on June 4, 1986. By then, he was no longer entitled to proceed with the demolition. Clearly then, the demolition of respondent's house by petitioner, despite his receipt of the TRO, was not only an abuse of right, but also an unlawful exercise of such right. In insisting on his alleged right, he wantonly violated this court's order and wittingly caused the destruction of respondent's house. Obviously, petitioner cannot invoke damnum absque injuria, a principle premised on the valid exercise of a right. Anything less or beyond such exercise will not give rise to the legal protection that the principle accords, and when damage or prejudice to another is occasioned thereby, liability cannot be obscured, much less abated. In the ultimate analysis, petitioner's liability is premised on the obligation to repair or to make whole the damage caused to another by reason of one's act or omission, whether done intentionally or negligently, and whether or not punishable by law. Proline Sports Center Incorporated versus Court of Appeals. Facts. By virtue of its merger with A.G. Spalding Brothers Incorporated, Questor, a U.S.-based corporation, became the owner of the trademark Spalding. Its exclusive distributor in the Philippines is Proline Sports Center. Proline filed a complaint with the NBI regarding the alleged manufacture of fake Spalding balls by Universal. When the NBI conducted a search on the premises of Universal, some 1,200 basketballs and volleyballs marked Spalding were found in the premises of Universal. 3 days after, on motion of the NBI, the court ordered to seal and padlock the instruments at Universal's factory. Proline and Questor filed a criminal complaint for unfair competition against Monico Sewani, the president of Universal. The criminal complaint against Sewani was eventually dismissed. Upon dismissal of the criminal case, Universal and Sewani filed a civil case for damages against Proline and Questor for allegedly filing an unfounded suit. Ruling: Proline and Questor could not have been moved by legal malice in instituting the criminal complaint for unfair competition, which led to the filing of the information against Sewani. Said the court, we are more disposed, under the circumstances, to hold that Proline, as the authorized agent of Questor, exercised sound judgment in taking the necessary legal steps to safeguard the interest of its principal with respect to the trademark in question. If the process resulted in the closure and padlocking of Universal's factory and the cessation of its business operations, these were unavoidable consequences of petitioners' valid and lawful exercise of their right. One who makes use of his own right does no injury. Qui jure suititur nullum damnum facit. If damage results from a person's exercising his legal rights, it is damnum absque injuria. Albinson Enterprises Corporation versus Court of Appeals. Supreme Court Records Annotated, Volume 217, page 16, decided 1993. Facts. Albinson Enterprises Corporation delivered to Guaranteed Industries mild steel plates, and as part payment thereof, AEC was given a check drawn against the account of EL Woodworks. The check bounced for the reason, account closed. Upon inquiry with the SEC, AEC discovered that the president of GII was one Eugenio S. Baltao. Upon further inquiry, AEC learned that EL Woodworks was registered in the name of one Eugenio Baltao. In addition, upon verification with Pacific Banking Corporation, AEC was advised that the signature appearing on the bounced check belonged to one Eugenio Baltao. Thereafter, AEC made an extrajudicial demand upon Eugenio S. Baltao. Therefore, AEC made an extrajudicial demand upon Eugenio S. Baltao for the payment or replacement of the dishonored check. Eugenio S. Baltao denied issuing the check and further claimed that Guaranteed was a defunct entity and could not have transacted business with AEC. Hence, AEC filed a complaint against Eugenio S. Baltao for violation of Batas Pambansa bilang 22. It turned out, however, that Eugenio S. Baltao was a namesake, in the person of his son, Eugenio Baltao III, who manages EL Woodworks. In the meantime, the Assistant Fiscal of Rizal filed the information against Eugenio S. Baltao. Eugenio S. Baltao immediately filed a motion for reinvestigation with the Provincial Fiscal of Rizal, who reversed the finding of the Assistant Fiscal. Because of the alleged unjust filing of the criminal case against him for a measly amount of 2,575 pesos, Eugenio S. Baltao filed before the RTC of Quezon City a complaint for damages against AEC, its owner, and one of its employees. AEC contended that the civil case against them was one for malicious prosecution. They asserted that the absence of malice on their part absolved them from any liability for malicious prosecution. Eugenio S. Baltao, on the other hand, anchored his complaint for damages on Articles 19, 20, and 21 of the Civil Code. Can Eugenio S. Baltao recover damages based on Articles 19, 20, and 21 of the Civil Code? Ruling: no. AEC et al. Could not be said to have violated the principle of abuse of rights for the following reasons. 1. What prompted AEC to file the case for violation of Batas Pambansa Bilang 22 against Eugenio S. Baltao was their failure to collect the amount of 2,575 pesos due to a bounce check, which they honestly believed and issued to them by Eugenio S. Baltao. 2. When AEC made an extrajudicial demand upon Eugenio S. Baltao, the latter did nothing to justify the case of mistaken identity at first hand. Instead, he waited in ambush and thereafter pounced on the hapless AEC at a time he thought was propitious by filing an action for damages. 3. The criminal complaint filed against Eugenio S. Baltao was a sincere attempt on the part of AEC to find the best possible means to collect the sum due to it. 4. Considering that GII, which received the goods in payment, of which the bouncing check was issued, is owned by Eugenio S. Baltao, AEC acted in good faith in filing the complaint before the provincial fiscal. 5. A civil action for damages for malicious prosecution is allowed under the new Civil Code, more specifically Articles 19, 20, 26, 29, 32, 33, 35, and 2219, 8 thereof, in order that such can prosper. However, the following elements must be present, to wit: 1. The fact of the prosecution and the further fact that the defendant was himself the prosecution, and that the action was finally terminated with an acquittal. 2. That in bringing the action, the prosecutor acted without probable cause. 3. The prosecutor was actuated or impelled by legal malice. In the case at bar, the second and third elements were not shown to exist. The presence of probable cause signifies, as a legal consequence, the absence of malice. In the instant case, it is evidence that AEC et al. Were not motivated by malicious intent or by sinister design to unduly harass Eugenio S. Baltao, but only by a well-founded anxiety to protect their rights when they filed the criminal complaint against Eugenio S. Baltao. In the case at bar, there is no proof of a sinister design on the part of AEC to vex or humiliate Eugenio S. Baltao by instituting the criminal case against him. While AEC may have been negligent to some extent in determining the liability of Eugenio S. Baltao for the dishonored check, the same is not so gross as to the amount to bad faith in warranting an award for damages. 6. In their error in proceeding against the wrong individual, was obviously in the nature of an innocent mistake and cannot be characterized as having been committed in bad faith. Thus, an award for damages and attorney's fees is unwarranted where the action was filed in good faith. If damage results from a person's exercising his legal rights, it is damnum absque injuria. In the final analysis, there is no proof or showing that AEC et al. Acted maliciously or in bad faith in the filing of the case against Eugenio S. Baltao. Consequently, in the absence of proof of fraud and bad faith committed by AEC et al., they cannot be held liable for damages. No damages can be awarded in the instant case, whether based on the principle of abuse of rights or for malicious prosecution. Garciano versus Court of Appeals, Supreme Court Records Annotated, Volume 212, page 436, decided 1992. Facts. Garciano was hired by Immaculate Conception Institute to teach during the 1981-1982 school year. On January 13, 1982, or before the school year ended, she applied for an indefinite leave of absence because her daughter was taking her to Austria. The president of the school approved of the application. On June 1, 1982, the school advised her, through her husband, that her services were being terminated, since there was no written contract of employment between her and the school. Upon her return from Austria and upon her inquiries as to her status, the board of directors of the school reinstated her, and the board likewise declared the notice of termination as null and void. Instead of reporting back for work, Garciano filed a complaint for illegal dismissal against some of the school officials and faculty members for discrimination and unjust and illegal dismissal. Ruling. The Supreme Court ruled that she was not entitled to damages. The court explained, Garciano's discontinuance from teaching was her own choice. While some school officials and faculty members wanted her services terminated, they actually did nothing to physically prevent her from reassuming her post. That the school principal disagreed the board of directors' decision to retain her, and some teachers allegedly threatened to resign en masse, even if true, did not make them liable for her for damages. They were simply exercising their right of free speech, or their right to dissent from the board's decision. Their acts were not contrary to law, morals, and good customs, or public policy. They did not illegally dismiss her, for the board's decision to retain her prevailed. She was ordered to report for work on July 5, 1982, but she did not comply with that order. Consequently, whatever loss she may have incurred in the form of lost earning was self-inflicted, volenti non fit iuria. With respect to Garciano's claim for moral damages, the right to recover them under Article 21 is based on equity, and he who comes to court to demand equity must come with clean hands. Article 21 should be construed as granting the right to recover to injured persons who are not themselves at fault. Moral damages are recoverable only if the case falls under Article 2219 in relation to Article 21. In the case at bar, Garciano is not without fault. Firstly, she went on indefinite leave of absence and failed to report back in time for the regular opening of classes. Secondly, for reasons known to herself alone, she refused to sign a written contract of employment. Lastly, she ignored the board of directors' order for her to report on July 5, 1982. Principle of abuse of rights. The principle of abuse of rights stated in Article 19 of the Civil Code departs from the classical theory that He who uses a right injures no one. The modern tendency is to depart from the classical and traditional theory and to grant indemnity for damages in cases where there is an abuse of rights, even when the act is not illicit. Article 19 sets certain standards which may be observed not only in the exercise of one's rights, but also in the performance of one's duties. These standards are the following: to act with justice, to give everyone his due, and to observe honesty and good faith. The law, therefore, recognizes the primordial limitation on all rights, that in their exercise the norms of human conduct set forth in Article 19 must be observed. As a right, though by itself legal because recognized or granted by law as such, may nevertheless become the source of some illegality. When a right is exercised in a manner which does not conform with the norms enshrined in Article 19 and results in damage to another, a legal wrong is thereby committed for which the wrongdoer must be held responsible. Article 19 was intended to expand the concept of torts by granting adequate legal remedy for the untold number of moral wrongs which is impossible for human foresight to provide, specifically in statutory law. If mere fault or negligence in one's acts can make him liable for damages for injury caused thereby, with more reason should abuse or bad faith make him liable. The absence of good faith is essential to abuse of right. Good faith is an honest intention to abstain from taking any unconscientious advantage of another, even though the forms or technicalities of the law, together with an absence of all information or belief of fact which would render the transaction unconscientious. In business transactions, it means good faith as understood by men of affairs. Elements of abuse of rights. The elements of an abuse of right under Article 19 are the following: 1. There is a legal right or duty. 2. Which is exercised in bad faith. 3. For the sole intent of prejudicing or injuring another. There is, however, no hard and fast rule which can be applied to determine whether or not the principle of abuse of rights may be invoked. The question of whether or not the principle of abuse of rights has been violated, resulting in damages under Articles 20 and 21 of the Civil Code, other applicable provision of law, depends on the circumstances of each case. The absence of good faith, however, is essential to abuse of right. Article 19 explained. While Article 19 may have been intended as a mere declaration of principle, the cardinal law on human conduct expressed in said article has given rise to certain rules. That is, that where a person exercises his rights, but does so arbitrarily or unjustly or performs his duties in a manner that is not in keeping with honesty and good faith, he opens himself to liability. The elements of an abuse of rights under Article 19 are: 1. There is a legal right or duty. 2. Which is exercised in bad faith. 3. For the sole intent of prejudicing or injuring another. This provision, together with the succeeding article on human relations, was intended to embody certain basic principles that are to be observed for the rightful relationship between human beings and for the stability of the social order. What is sought to be written into law is the pervading principle of equity and justice above strict legalism. Articles 19, 20, and 21 compared. Although the requirements of each provision are different, these three articles are all related to each other. But while Article 19 lays down the rule of conduct for the government of human relations and for the maintenance of social order, it does not provide a remedy for its violation. Generally, an action for damages under either Article 20 or Article 21 would be proper. Article 20 speaks of the general sanction for all other provisions of law, which do not especially provide for their own sanction. Thus, anyone who, whether wilfully or negligently, in the exercise of his legal right or duty, causes damage to another, shall indemnify his victim for injuries suffered thereby. Article 21 deals with acts contra bonus mores and has the following elements. 1. There is an act which is legal. 2. But which is contrary to morals, good customs, public order, or public policy. And 3. And it is done with intent to injure. There is a common element under Articles 19 and 21, and that is the act must be intentional. However, Article 20 does not distinguish. The act may be done either willfully or negligently. Thus, under any of these provisions of law, an act which causes injury to another may be made the basis of an award of damages. Velayo versus Shell Company of the Philippines. Philippine Reports, Volume 100, page 186, decided 1956. Facts. The commercial airlines on the verge of bankruptcy met with all his creditors. It was agreed that Cali's assets, including C-54 plane that was still in California, would be sold and the proceeds distributed to the creditors. Right after the meeting, Shell Company shrewdly made a telegraphic assignment of its credit to a sister corporation in the U.S., which immediately secured attachment and sale of Cali's plane in California, the proceeds of which were totally applied to the satisfaction of its claim. Can the Shell Company in the Philippines be made to pay for damages to other creditors of Cali? Ruling. The case at bar falls squarely within the purview of the principle of abuse of rights embodied in Article 19 of the Civil Code. True, this article contains essentially a mere declaration of principles, yet such declaration is implemented by Article 21, a sequent of Article 19, which declares that any person who willfully causes loss or injury to another in a manner that is contrary to morals, good customs, or public policy shall compensate the latter for damages. Shell Company is liable for damages because it did not show good faith and honesty. Globe Mackay Cable and Radio Corporation versus Court of Appeals. Supreme Court Records Annotated, Volume 176, page 778, decided 1989. Facts. Restituto Tobias was employed by Globe Mackay as purchasing agent and administrative assistant, the engineering operations manager. The fictitious purchases and other fraudulent transactions were discovered, and the same were attributed to Tobias, who ironically was the one who actually discovered and reported the anomalies. One day after Tobias made the report, Herbert Henry, the EVP and the GM of Globe, confronted him by stating that he was the number one suspect and ordered him to take a 1-week forced leave, not to communicate with the office, to leave his table drawers open, and to leave the office keys. When Tobias returned to work after his forced leave, Henry again went to him and called him a crook and a swindler. He was then ordered to take a lie detector test. He was also instructed to submit specimen signatures of his handwriting, signature and initials for examination by the police investigators to determine his complicity in the anomalies. The Manila police investigators submitted a laboratory crime report clearing Tobias of participation in the anomalies. Not satisfied with the police report, Henry hired a private investigator who submitted a report finding Tobias guilty. This report, however, expressly stated that further investigation was still to be conducted. Nevertheless, Henry issued a memo suspending Tobias from work preparatory to the filing of criminal charges against him. Thereafter, the Metro Manila Police Chief Document Examiner, after investigating other documents, reiterated his previous finding that the handwritings, signatures, and initials appearing in the checks and other documents involved in the fraudulent transactions were not those of Tobias. The lie detector test conducted on Tobias also yielded negative results. Notwithstanding the two police reports exculpating Tobias, Henry filed several complaints of estafa against Tobias, all of which were dismissed. In the meantime, Tobias received a notice from Globe Mackay that his employment has been terminated. Tobias filed a complaint for illegal dismissal, which case was settled amicably. Unemployed, Tobias sought employment with the Republic Telephone Company, Ritelco. However, Henry, without being asked by Ritelco, wrote a letter to the latter stating that Tobias was dismissed by Globe Mackay due to dishonesty. Tobias filed a civil case for damages against Globe Mackay and Henry, petitioners for short. Petitioners contend that they could not be made liable for damages in the lawful exercise of their right to dismiss Tobias. Tobias, on the other hand, contends that because of petitioners' abusive manner in dismissing him, as well as for the inhuman treatment he got from them, the petitioners must indemnify him for the damage that he had suffered. Issue whether or not the petitioners are liable for damages. Ruling. Petitioners have indeed abused the right that they invoke, causing damage to Tobias, and for which the latter might be indemnified. Even granting that petitioners might have had the right to dismiss Tobias from work, the abusive manner in which the right was exercised amounted to a legal wrong, for which petitioners must now be held liable. Moreover, the damage incurred by Tobias was not only in connection with the abusive manner in which he was dismissed, but was also the result of several other quasi-delictual acts committed by petitioners. The following reasons convinced the court to award damages. 1. Upon reporting for work, Tobias was confronted by Henry, who said, "Toby, you are a crook and a swindler in the company." Considering that the first report made by the police investigators was yet to be submitted, the statement made by Henry was baseless. The imputation of guilt without basis in the pattern of harassment during the investigations of Tobias transgressed the standards of human conduct set forth in Article 19 of the Civil Code. The court has already ruled that the right of the employer to dismiss an employee should not be confused with the manner in which the right is exercised and the effects following therefrom. If the dismissal is done abusively, then the employer is liable for damages to the employee. Under the circumstances of this case, the petitioners clearly failed to exercise in a legitimate manner their right to dismiss Tobias, giving the latter the right to recover damages under Article 19 in relation to Article 21 of the Civil Code. 2. Several other tortuous acts were committed by petitioners against Tobias after the latter's termination from work. After the filing of the criminal complaints, Tobias talked to Henry to protest the actions taken against him. In response, Henry cut short Tobias' protestations by telling him to just confess or else the company would file 100 more cases against him until he landed in jail. Henry added, "You Filipinos cannot be trusted." The threat unmasked petitioners' bad faith on the various actions taken against Tobias. On the other hand, the scornful remark about Filipinos, as well as Henry's earlier statements about Tobias being a crook and swindler, are clear violations of Tobias' personal dignity. See Article 26 of the Civil Code. 3. The next tortuous act committed by petitioners was the writing of a letter to Retelco stating that Tobias had been dismissed by Globe McKay due to dishonesty. Because of the letter, Tobias failed to gain employment with Retelco, and as a result of which, Tobias remained unemployed for a longer period of time. For this further damage suffered by Tobias, petitioners must likewise be held liable for damages consistent with Article 2176 of the Civil Code. 4. Finally, there is the matter of the filing by petitioners of 6 criminal complaints against Tobias. In the instant case, the petitioners acted in bad faith in filing the criminal complaints. Considering the haste in which the criminal complaints were filed, the fact that they were filed during the pendency of the illegal dismissal case against petitioners, the threat made by Henry, the fact that the cases were filed notwithstanding the 2 police reports exculpating Tobias from involvement in the anomalies committed against Globe McKay, coupled by the eventual dismissal of all cases, the court is led into no other conclusion that the petitioners were motivated by malicious intent in filing the 6 criminal complaints against Tobias. RCPI versus Court of Appeals. Facts. RCPI sent a telegram through its Manila office to Loreto Dionela, reading as follows. Loreto Dionela, Cabangan, wire arrival of check per 1:15 p.m. Sa'yo walang pakinabang dumating ka dyan. Wala kang padala dito, kahit bulbul mo. Dionela filed a complaint for damages against RCPI alleging that the defamatory words on the telegram sent to him were not only wounded his feelings but also caused him undue embarrassment and affected his business as well as because other people have come to know of said defamatory words. RCPI alleges, as its defense, that the additional words in Tagalog was a private joke between the sending and receiving operators, that they were not addressed to or intended for plaintiff and therefore did not form part of the telegram, and that the Tagalog words are not defamatory. The telegram sent to its facilities was received in its station at Legazpi City. Nobody other than the operator manned the teletype machine, which automatically receives the telegrams being transmitted. The said telegram was detached from the machine and placed inside a sealed envelope and delivered to Dionela, obviously as it is. The additional words in Tagalog were never noticed and were included in the telegram when delivered. The lower court held RCPI directly and primarily liable for damages to Dionela. The Court of Appeal sustained and the lower court's decision, but reduced the award for damages. RCPI appealed to the Supreme Court, alleging that the Court of Appeals erred in holding that RCPI should answer directly and primarily for the civil liability arising from the criminal action of its employees. Issue: is RCPI directly and primarily liable to Dionela for damages? Ruling: yes. The action for damages was filed directly against RCPI, not as an employer subsidiarily liable under the provisions of Article 1161 of the New Civil Code in relation to Article 103 of the Revised Penal Code. The cause of action of Dionela is based on Articles 19 and 20 of the New Civil Code, as well as on petitioner's breach of contract through the negligence of its own employees. RCPI is a domestic corporation engaged in the business of receiving and transmitting messages. Every time a person transmits a message through the facilities of RCPI, a contract is entered into. Upon receipt of the rate or fee fixed, the petitioner undertakes to transmit the message accurately. There is no question that in the case at bar, libelous matters were included in the message transmitted without the consent or knowledge of the sender. There is a clear case of breach of contract by the petitioner in adding extraneous and libelous matters in the message sent to Dionela. As a corporation, the petitioner can act only through its employees. Hence, the acts of its employees in receiving and transmitting messages are the acts of RCPI. To hold that RCPI is not liable directly for the acts of its employees in the pursuit of RCPI, not liable directly, not liable directly, okay, sorry about that. The acts of its employees in receiving and transmitting messages are the acts of RCPI. To hold that RCPI is not liable directly for the acts of its employees in the pursuit of RCPI's business is to deprive the general public availing of the services of RCPI of an effective and adequate remedy. In most cases, negligence must be proved in order that plaintiff may recover. However, since negligence may be hard to substantiate in some cases, we may apply the doctrine of res ipsa loquitur. The thing speaks for itself by considering the presence of facts or circumstances surrounding the injury. Breach of promise to marry. Breach of promise to marry, generally not actionable. The existing rule is that a breach of promise to marry per se is not an actionable wrong. As decided in Gashem Shukat Baksh versus Court of Appeals, Supreme Court Records Annotated, Volume 219, page 115, citing Hermosissima versus Court of Appeals, Philippine Reports, Volume 109, page 629, decided 1916, and also Estopa versus Piansay, Philippine Reports, Volume 109, page 614, decided 1960. Congress deliberately eliminated from the draft of the new Civil Code the provisions that would have made it so. The reason, therefore, is set forth in the report of the Senate committees on the proposed Civil Code. That is, the elimination of this chapter is proposed. That breach of promise to marry is not actionable has been definitely decided in the case of De Jesus versus Siquia, Philippine Reports, Volume 58, page 866, decided 1933. The history of breach of promise suits in the United States and in England has shown that no other action lends itself more readily to abuse by designing women and unscrupulous men. And it is this experience which has led to the abolition of rights of action in the so-called heart bomb suites in many of the American states. TanaCon versus Court of Appeals, Supreme Court Records Annotated, Volume 18, page 994, decided 1966. Facts. From December 1957, Apolonio Tanhanco courted Araceli Santos, both being of adult age. Tanhanco expressed and professed his undying love and affection for Santos, who also in due time reciprocated the tender feelings. In consideration of Tanhanco's promise of marriage, Santos consented and acceded to Tanhanco's request for carnal knowledge. That regularly until December 1959, through his protestations of love and promises of marriage, Tanhanco succeeded in having carnal access to Santos, as a result of which the latter conceived a child. Due to her pregnant condition and to avoid embarrassment and social humiliation, Santos had to resign her job, and thereafter she became unable to support herself and her baby. Because of Tanhanco's refusal to marry Santos, the latter filed a complaint against the former for recovery of damages. Ruling: Santos is not entitled to damages. The facts stand that for one whole year, from 1958 to 1959, Santos, a woman of adult age, maintained intimate sexual relations with Tanhanco, with repeated acts of intercourse. Such conduct is incompatible with the idea of seduction. Plainly, there is here voluntariness and mutual passion. For had Santos been deceived, Had she surrendered exclusively because of the deceit, artful persuasions, and wiles of Tanhanko, she would not have again yielded to his embraces, much less 1 year, without exulting early fulfillment of the alleged promises of marriage, and would have cut short all sexual relations upon finding that Tanhanko did not intend to fulfill his promises. Hence, no case is made under Article 21 of the Civil Code. Constantino versus Mendez, Supreme Court Records Annotated, Volume 209, page 18, decided 1992. Facts. Amelita met Ivan at Tony's restaurant where she worked as a waitress. The day following the first meeting, Ivan invited Amelita to dine with him at Hotel Enrico, where he was billeted, and while dining, Ivan professed his love and courted Amelita. In that same evening, Ivan brought Amelita inside his hotel room and through promise of marriage succeeded in having intercourse with the latter. After the act, Ivan confessed to Amelita that he was a married man. They repeated their sexual contacts in the months of September and November 1974, as a result of which Amelita got pregnant. The latter's plea for help and support fell on deaf ears. Amelita thus filed an action for acknowledgement, support, and damages against Ivan. Ruling. Mere sexual intercourse is not by itself a basis for recovery. Damages could only be awarded if sexual intercourse is not a product of voluntariness and mutual desire. At the time she met Ivan at Tony's restaurant, Amelita was already 28 years old, and she admitted that she was attracted to Ivan. Her attraction to Ivan is the reason why she surrendered her womanhood. Had she been induced or deceived because of a promise of marriage, she could have immediately severed her relation with Ivan when she was informed after her first sexual contact sometime in August 1974 that he was a married man. Her declaration that in the months of September, October, and November 1974 they repeated their sexual intercourse only indicates that passion, and not the alleged promise of marriage, was the moving force that made her submit herself to Ivan. Breach of promise to marry, when actionable. To be actionable, there must be some act independent of the breach of promise to marry, such as if there is fraud or deceit. Where a man's promise to marry is in fact the proximate cause of the acceptance of his love by a woman and his representation to fulfill that promise hereafter becomes the proximate cause of the giving of herself unto him in sexual congress, proof that giving that he proof that he had in reality no intention of marrying her, and that the promise was only a subtle scheme or deceptive device to entice or inveigle her to accept him and to obtain her consent to the sexual act, could justify the award of damages, but because of the fraud and deceit behind it, and the willful injury to her honor and reputation which followed thereafter, it is essential, however, that such injury should have been committed in a manner contrary to morals, good customs, or public policy. Pe versus Pe. Supreme Court Records Annotated, Volume 5, page 200, decided 1962. Facts. Alfonso Pe, a married man, was an adopted son of a Chinaman named Pe Beko, a collateral relative of Lolita Pe's father. Because of such fact and the similarity in their family name, Alfonso became close to Lolita's family, who regarded him as a member of their family. Sometime in 1952, Alfonso frequented the house of Lolita on the pretext that he wanted her to teach him how to pray the rosary. The two eventually fell in love with each other and conducted clandestine trysts not only in the town of Gasan but also in Boac, where Lolita used to teach in a barrio school. They exchanged love notes with each other. The rumors about their love affair reached the ears of Lolita's parents sometime in 1955, and since then Alfonso was forbidden from going to their house and from further seeing Lolita. The affair continued nonetheless. On day One day in 1957, Alfonso wrote Lolita a note asking her to have a date with him. When Lolita went to see him, the two decided to elope, and Lolita never returned home. The parents, brothers, and sisters of Lolita sued Alfonso for damages under Article 21 of the Civil Code. Ruling: Alfonso is liable for damages. The circumstances under which Alfonso tried to win Lolita's affection cannot lead to any other conclusion than that it was he who, through an ingenious scheme or trickery, seduced the latter to the extent of making her fall in love with him. No other conclusion can be drawn from the chain of events than that the defendant not only deliberately, but through a clever strategy, succeeded in winning the affection and love of Lolita to the extent of having illicit relations with her. The wrong he has caused her and her family is indeed immeasurable, considering the fact that he is a married man. Verily, he has committed an injury to Lolita's family in a manner contrary to morals, good customs, and public policy as contemplated in Article 21 of the new Civil Code. Gashem Shukat Baksh versus Court of Appeals. Supreme Court Records Annotated, Volume 219, page 115. Decided 1993. Facts: Gashem is an Iranian citizen and an exchange student taking a medical course at Lyceum Northwestern Colleges in Tagupan City. Sometime in 1987, Gashem courted Marilu Gonzalez and proposed to marry her. Marilu accepted his love on the condition that they would get married, and they agreed to get married after the end of the school semester, which was in October 1987. Gashem then visited Marilu's parents in Banyaga, Bugalyon, Pangasinan to secure their approval to the marriage. Sometime in August 1987, Gashem forced Marilu to live with him in the Lozano apartments. She was a virgin before she began living with him. Soon, Gashem's attitude towards Marilu started to change. He maltreated and threatened to kill her, and as a result of such maltreatment, she sustained injuries. At the confrontation before the representative of the barangay captain of Guilig, Gashem repudiated their marriage agreement because he was already married to someone living in Bacolod. Marilu thus filed a complaint for damages against Gashem. Ruling: Gashem is liable for damages. The Supreme Court ruled that where a man's promise to marry is in fact the proximate cause of the acceptance of his love by a woman, and his representative to fulfill that promise thereafter becomes the proximate cause of the giving of herself unto him in sexual congress, proof that he had, in reality, no intention of marrying her, and that the promise was only a subtle scheme or deceptive device to entice or inveigle her to accept him and to obtain her consent to the sexual act, could justify the award of damages pursuant to Article 21, not because of such promise to marry, but because of the fraud and deceit behind it, and the willful injury to her honor and reputation which followed thereafter. It is essential, however, that such injury should have been committed in a manner contrary to morals, good customs, or public policy. In the instant case, it was Gashem's fraudulent and deceptive protestations of love for and promise to marry Marilu that made her surrender her virtue and womanhood to him and to live with him in the honest and sincere belief that he would keep said promise. And it was likewise this fraud and deception in Gashem's part that made Marilu's parents agree to their daughters living in with him preparatory to their supposed marriage. In short, Marilu surrendered her virginity, the cherished possession of every single Filipina, not because of lust, but because of moral seduction. Okay, so if actionable, if expenses are actually incurred, where the plaintiff has actually incurred expenses for the wedding and the necessary incidents thereof, the plaintiff has the right to recover money or property advanced by him upon the faith of such promise. Wasmer versus Velez. Supreme Court Records Annotated, Volume 12, page 648. Facts: Francisco Velez and Beatriz Wasmer, following their mutual promise of love, decided to get married and set September 4, 1954 as the big day. On September 2, 1954, Velez left a note for his bride-to-be which reads, "Dear Beth, we have we will have to postpone wedding. My mother opposes it. I'm leaving on the convoy today. Please do not ask too many people about the reason why. That would only create a scandal. Paking." Thereafter, Velez did not appear, nor was he heard from again. Wasmer sued Velez for damages. Velez contended that there was no provision of the Civil Code authorizing an action for a breach of promise to marry. The records reveal, however, that on August 23, 1954, Wasmer and Velez applied for a marriage license, which was subsequently issued. Their wedding was set for September 4, 1954. Invitations were printed and distributed to relatives, friends, and acquaintances. The bride-to-be's trousseau, party dresses, and other apparel for the important occasion were purchased. Dresses for the maid of honor and the flower girl were prepared. A matrimonial bed with accessories was bought. And then, with but 2 days before the wedding, Velez simply called off the wedding, went to Mindanao, and never returned and was never heard from again. Ruling: this was not a mere breach of promise to marry. Mere breach of promise to marry is not an actionable wrong, but to formally set a wedding and go through all the above described preparation and publication, only to walk out of it when the matrimony is about to be solemnized is quite different. This is palpably and unjustifiably contrary to good customs, for which defendant must be held answerable in damages in accordance to Article 21 of the Civil Code. When a woman is forcibly abducted and when the man forcibly abducted the woman and had carnal knowledge with her against her will, and thereafter promised to marry her in order to escape criminal liability, only to thereafter renege on such promise after cohabiting with her for 21 days, such acts irremissibly constitute acts contrary to morals and good customs. These are grossly insensate and reprehensible transgressions. These are grossly insensate and reprehensible transgressions which indisputably warrant and abundantly justify the award of moral and exemplary damages pursuant to Article 21 in relation to paragraphs 3 and 10, Article 2219, and Articles 2229 and 2234 of the Civil Code. Bunag Jr. versus Court of Appeals. Supreme Court Records Annotated, Volume 211, page 440, decided 1992. Facts: on the afternoon of September 8, 1973, while Zenaida Cirillo was on her way to school, she was invited by Conrado Bunyag, a former boyfriend, for merienda at Aristocrat Restaurant. Instead of having merienda at Aristocrat Restaurant, Bunyag brought her to a motel where Thereafter, Bunyag brought Cirilo to the house of his grandmother in Parañaque, where they lived for 21 days as husband and wife. On the night of September 8, 1973, the father of Bunyag arrived and assured Cirilo that the following day, she and Bunyag would go to Bacoor, Cavite to apply for a marriage license. Indeed, the two applied for a marriage license. On September 29, 1973, Bunyag left and never returned, humiliating Cirilo and compelled her to go back to her parents on October 1973. Cirilo filed for a complaint for damages for alleged breach of promise to marry against Bunyag and his father. Ruling. It is true that in this jurisdiction, we adhere to the time-honored rule that an action for a breach of promise to marry has no standing in the civil law, apart from the right to recover money or property advanced by the plaintiff upon the faith of such promise. Generally, therefore, a breach of promise to marry per se is not actionable, and the necessary incidents thereof. Under the circumstances obtaining in the case at bar, the acts of Bunyag in forcibly abducting Cirilo and having carnal knowledge with her against her will, and thereafter promising to marry her in order to escape criminal liability, only to thereafter renege on such promise after cohabiting with her for 21 days, irremissibly constitute acts contrary to law and good customs. These are grossly insensate and reprehensible transgressions which indisputably warrant and abundantly justify the award of moral and exemplary damages pursuant to Article 21 in relations to paragraphs 3 and 10, Article 2219 and Article 2229 and Article 2234 of the Civil Code.